Hello everybody and welcome back. So there is some updates on the paparazzi front with the courts, and this was filed yesterday, Monday. Paparazzi accessories versus Jerry, Melissa, Kylie, all the people. Okay, so it's a memorandum decision and order denying a motion, and let me tell you what that motion is. Alright, this matter is before the court on counterclaim defendant's motion to server. For the reasons discussed below, the court will deny the motion without prejudice. Okay, so that's very interesting and very telling. So I'm gonna keep reading, and I wanted to clarify what without prejudice means. So, let me see. What does without prejudice mean? It means if a case is dismissed with prejudice, it means that you can most likely refile, if I remember that correctly. And if it's dismissed without prejudice, it means you can't. Okay? So it was dismissed. The court will deny the motion without prejudice. Okay, so without prejudice, the rule will generally prevent statements made in a genuine attempt to settle an existing dispute, whether made orally or in writing. Okay. Being put before the court as evidence of admissions against the interactions of the party which was made against them. One reason for having a without prejudice rule is the public policy of encouraging parties or potential parties to litigation to settle their disputes out of court. The rationale is the settlement discussions, and it is hoped settlement itself will be facilitated if parties are able to speak freely, secure in the knowledge that what they have said, and in particular, any admissions which they might have made or tried to settle that matter, may not be used against them should settlement discussions actually fail. The inclusion of the words without prejudice will not necessarily bring the communication within the ambient without prejudice privilege. It's a genuine attempt to try and settle an existing dispute. Okay, so with this Paparazzi v. Sorensen and all the other things that are going on, let's keep going down. So the background. This is the counterclaim that Jerry and all those people filed. Okay, this is their counterclaim that they filed against Paparazzi. You know, Paparazzi sued them first. They followed through with a counterclaim. Okay, and we went over that in a past video, and I'll link it at the end of this one. So, this is one of 6 cases pending in this district involving Paparazzi LLC. As a party, Paparazzi sought to consolidate the other cases into the Teskey action. Through this motion, Paparazzi and the other counterclaim defendants seek to sever the counterclaims against them so they may subsequently move to consolidate them into Teskey. Recently, the Honorable David Barlow denied Paparazzi's motion to consolidate, finding, among other things, that consolidation would not promote judicial economy. Instead, Judge Barlow ordered all cases reassigned to him and referred to the undersigned. Okay? And that's number 4. I'm going to keep reading. The discussion. The court has broad discretion to server claims. When considering whether the server claims, the question will be answered whether severance will serve the ends of justice and further promote the efficient deposition of a litigation. The factors to be considered are potential prejudice to the parties and the potential confusion to the jury and the relative convenience and economy. Considering these factors, the court will deny the counterclaim defendant's motion. As noted, the purpose of severance was to remove the counterclaims so they could be consolidated. Okay, so it lists all the other cases against Paparazzi, which were all moved to the state of Utah. There's Johnson versus Paparazzi, Gilbert versus Paparazzi, Burgess versus Paparazzi, Hollins versus Paparazzi, and Teskey versus Paparazzi. Okay, as you can see, bunches of cases. And then we have these other cases which are being used to kind of say this is why. Okay. So, they should be consolidated with the other pending actions. However, since the consolidation has now been denied, severance no longer furthers the prompt and efficient disposition of this litigation. Further, severance may harm the counterclaim plaintiff's ability to present their claims in a cohesive fashion. I'm gonna pause. Actually, we only have 4. Anytime, cuckoo. Alright, it should be done now. Okay. Further, severance may harm their ability to prove their case. Now, I love that this was put in this document because Paparazzi's attorneys, and this is my opinion, this is not fact, but when they moved to put all of these cases, the ones that were filed against them, with Jerry and Party's counterclaim, they were trying to prevent them going to war. It's basically, it's a way to say, we're going to war and we don't want to go to war with all these people, so we want them to just be one person instead of these 6 litigants. And the judge is like, no, this is going to make it harder for them to present their claims against you. You sued them first, they can counterclaim. These don't match. Their counterclaims are separate from the class action suits that are being filed all across the country. So it's extremely interesting that this was like, nope, sorry, denied, okay? So they did this to promote convenience and judicial economy. So Paul Kohler, the magistrate judge, signed this and said, I'm sorry, no, it's denied without prejudice. So the way I look at this is a nail in the coffin of paparazzi. Okay, this is a small, short, sweet nail in the coffin of paparazzi accessories, and I'm grateful to see that. This is good news. Okay, this is good news. Jerry and everybody that's in the Paparazzi v. Sorensen, all these people listed here, this is going to benefit them. Okay, in the long run, it will benefit them. It's going to hurt paparazzi because now paparazzi has to fight 2 separate lawsuits because they did combine all the class actions into one, I believe. But this one, the counterclaim that Jerry and her company of peeps filed, So to judicial economy, yeah, you filed a lawsuit against those people. They filed a counterclaim. You need to pay your attorneys to fight that counterclaim and the lawsuit that you filed against them. Now, I'm sorry, paparazzi, but all of those lawsuits that others have filed against you, I'm sorry that you can't, combine them to save money on attorney's fees and costs. But, that's the way the cookie crumbled. It's almost been a full year since you took those lead and nickel free claims down off your website. Okay? It's been almost a full year, paparazzi, since you took that down. Now, that's your problem. That is your problem. Now you're lead and nickel compliant, and you since eliminated your Starlit Shimmer line. Why? Because I don't know why. You took those down. Alrighty then, but why? Your product has become increasingly cheaper in quality. Your product, from what people have sent my way, stinks. It literally smells. Smells like chemicals, smells like motor oil, smells terrible. And those stinky, smelly pieces, yeah, I turn them over to a certain attorney general, yeah. So, I don't know what you're trying to get away with, but I'm kind of glad with judicial expediency, your motion was denied. So that's the update on the paparazzi litigation front. So everyone have a wonderful day. Thanks for joining me. Don't forget to like, comment, share, subscribe, share your thoughts. I love hearing them. And make it a great day. Bye.